In the worst of times, a misguided group arose, insulting the Imams, condemning taqleed, and calling on others to do the same, even though most of their criticisms and all their proofs are based on taqleed of their predecessors. In reality, these people are greater muqallids than the muqallids themselves, for the muqallids only oblige a non-mujtahid to imitate a mujtahid, while these people obligate the mujtahid to imitate them. This is On Taqleed, Ibn al-Qayyim's critique of authority in Islamic law. I'm Joe Bradford, and welcome to Inside My Library. This book was printed by Oxford University Press and is essentially a study of Muhammad ibn Abi Bakr al-Zura'i's work known as I'lam al-Muwaqqi'in, better known as Ibn al-Qayyim al-Jawzi or Ibn Qayyim al-Jawziyya. Ibn al-Qayyim was a Hanbali theologian, a jurist, and a legal theorist from Damascus. He was very popular for his spiritual slant, and much of his other work has been viewed only in the light of his teacher, Ibn Taymiyyah, or in the darkness of his shadow. The author, Abdurrahman Mustafa, notes rightfully that Ibn al-Qayyim's body of work has been narrowly covered in Western academic studies. And this book on Taqleed is a step in the right direction. It produces a faithful rendition of Ibn al-Qayyim's treatment, coupled with a deft introduction to the topic. Now, the author cites a lack of any substantial coverage of Ibn al-Qayyim's works in any Western language, along with the ubiquity of his works in the Islamic world. So the main catalyst behind the production of this volume is to present Ibn al-Qayyim not just as a mouthpiece of his teacher Ibn Taymiyyah, but as the influential legal theorist, legal jurist, and theologian he was in his own right. Now, the progress of any legal system can be said to be directly correlated to the freedom that its jurists enjoy to exercise independent reasoning. Because of this, the topic of ijtihad and taqleed in Islamic law have taken a lion's share of Western academic discussion. Ijtihad, the ability of the jurist to independently interpret the law, was to be the hallmark of the Islamic legal system. Taqleed, on the other hand, was criticized for limiting the law and its applicability. Now, Mustafa, in this book, he translates taqleed as imitation, and it is a means for operationalizing legal precedent by obliging those unable to interpret the law to imitate those scholars' decisions that came before them. What this did is it created a hierarchy of legal interpretation and a level of standardization of how the law is applied. So muftis, qadis, and others of the scholarly community transitioned from engaging with the sources of Islamic thought directly to engaging solely with the opinions and standard texts of their respective schools. It's here that the criticism of taqleed is most relevant, and which Ibn al-Qayyim laments the most in this work. On Taqleed is a work in three parts. The first is an introduction to the concept of taqleed and Ibn al-Qayyim's positions on the topic. Part 2 is entitled An Exposition on Imitation, and it lays out Ibn al-Qayyim's arguments against imitation. Part 3 consists of a dialogue between Ibn al-Qayyim and an interlocutor promoting a pro-taqleed stance. Mustafa weaves the arguments used by Ibn al-Qayyim mentioned in the second and third parts into a narrative that spans the length of Islamic history from the modern period, reaching back to the period of the great Imams like Shafi'i. He frames the discussion of taqleed in the modern debates of Deobandi and Ahli Hadith scholars of Southeast Asia, which shows some applicability of these arguments even today. He then presents the topic's main arguments through the opinions of select scholarly figures throughout Islamic history. Pro and anti-taqleed opinions are surveyed, interspersed with connections back to Ibn al-Qayyim's work I'lam al-Muwaqqi'in an Rabbil Alameen, i.e. a note to those who sign in the name of the Lord of the Worlds, from which the translated chapters of On Taqleed are drawn from. At the end of the introduction, Mustafa does well in summarizing Ibn al-Qayyim's tripartite system for contextualizing the use of taqleed, which sets the boundaries for its use. Now, these are summarized in the introduction by Mustafa, then expounded upon in the second and third parts by Ibn al-Qayyim himself. These boundaries, when crossed, would exhibit the type of taqleed that is inexcusable in Ibn al-Qayyim's opinion. The first of these boundaries is the supremacy and the sufficiency of scripture, i.e. the Quran and Sunnah, for solving legal and theological problems. The second principle is that revelation and human reason are never contradictory, and this was a principle that was championed by his teacher, Ibn Taymiyyah. The third principle that Ibn al-Qayyim bases his system of limiting the institution of taqlid on is the primacy of the opinions of the Salaf, or the early generations, which exemplify the first two principles and show their proper and correct application, in his view. The actions of the Salaf are so important to him because they delineate what is considered acceptable and applicable in the area of reason. So through this principle, Ibn al-Qayyim reiterates the boundaries for the use of reason, which does not contradict with revelation. It can rightly be said that taqlid is an elastic term, and it means many different things to many different people. Pro-taqlid scholars are advocating for a mimetic, normative tradition of Islamic thought, one predicated on uniformity and unbroken continuity. Anti-taqlid scholars are advocating for more open-ended, primary access to and application of sacred text of Islam in everyday life. What Ibn al-Qayyim is arguing for is a middle ground between these two stances, in which taqlid is better described as emulation than imitation, where the mufti attempts to reach a conclusion on par with or surpassing those that preceded him. Now here, Mustafa aligns Ibn al-Qayyim with other legal heavyweights that held this position as well, like Shihab ad-Din al-Qarafi and Muhammad ibn Idris al-Shafi'i. And he shows that they advocated for a systematized analysis of scripture, one in which life was not limited by scriptural historicism, like Ahl al-Zahir, nor was it secondary to or viewed as equal with the very human and very fallible faculty of human reason, like Ahl al-Ray. Ibn al-Qayyim frames this distinction as the difference between taqlid, imitation, and ittiba', or following. The summary of arguments found in the introduction succinctly create a backdrop for reading Mustafa's translation. This is a great book, and I think everyone should get it. This translation relies heavily on Mashhur Hassan Salman's critical edition and annotation of Ibn al-Qayyim's I'lam al-Muwaqqi'in that was published in 2002, although there are other prints in Arabic. Now, while Mustafa does leave out parts of the original work that pertain to taqlid, for the most part they're superfluous to the arguments that are presented in the translation sections, and for the most part anecdotal. This doesn't detract from the worth of the book at all. The translation is adept, accurate, and supported well by the introduction. This volume, to be honest, is a much needed addition to the body of work on Ibn Taymiyyah and Ibn al-Qayyim and Hanabila and Mamluk area Islamic law and Islamic studies in general. The translator's laudable effort will hopefully be the catalyst needed to encourage further study of these often neglected areas in the intellectual history of Islam and the Middle East. If you've enjoyed this video, then you may want to read my published review of this book, which is available in the Journal of Comparative Islamic Studies, and you can also access a draft of on my academia.edu page. So, did this book interest you? If so, what about it interested you? Any other books like it that you'd recommend? If you've enjoyed this video, please like it, subscribe, share it with your friends, and let me hear from you in the comments, and I'll see you next time inside my library.